Welcome back to On the Move with Victor Shi. This is Victor Shi. It is Tuesday, June 27th, and today we begin this episode with one statement that is becoming more irrefutable at this time and that everyone should understand, and that is that Donald Trump is a traitor to this nation. He stole top secret classified information from the White House, was asked numerous times to return them, but he chose not to. And based on what we know from the indictment, as well as a new recording obtained by CNN last night, he waved them around like he was in first grade, placed them in the bathroom, and treated them with the type of reckless disregard that none of us should stand for. So my questions are, what's next in this case? How soon will it be before a trial and a verdict? What are the roadblocks that could come about in the next few weeks and months? And I am joined by the perfect person to discuss this. He is a former CIA attorney and an intelligence professional, Brian Greer. Brian, it is so great to see you. Thank you so much for joining me today.
Thank you so much for having me.
So I have to begin with this new audio recording from Trump last night. And I thought reading the indictment was revolting enough, but hearing Donald Trump basically brag about the document so cavalierly was even more angry. And I'm wondering what your initial reactions were when you listened to it.
Yeah, I mean, obviously, just on an emotional level, it's jaw-dropping, right? Had the cavalierness. And as a former national security official myself, it's just demoralizing and just takes your breath away that he would be so cavalier, like I said, with the classified national security document. And then putting on my lawyer hat, it's obviously, very damaging for him and his prosecution. To be clear, he's not charged with this document, either for retaining it or for disseminating it to someone else. We could talk about why that might be, but it's still bad for even the other 31 documents that he's charged with, because it shows that he knew that they were still sensitive, and that he knew they had not been declassified, notwithstanding all the claims that they've been magically declassified. He knew they hadn't. And even his Presidential Records Act defense, like that it shows too that this was not some document that had somehow become his personal document. And that's all relevant because the government has to show that he willfully retained these documents. And this undercuts all that because it shows that he knew exactly what he was doing.
So putting on your lawyer hat on for another second, I mean, is there any defense you can think of left for the Trump team after? I mean, you mentioned that this wasn't even in the evidence, but I mean, given what we know so far, just based off of publicly available information, is there any sort of justifiable defense from Team Trump at this point? And if so, what would that be?
No, I mean, normally the defense in this case would just be that the information isn't what's called national defense information, which is almost the equivalent to classified information, technically a little different, that it wasn't closely held by the government. Obviously, these records prepared for him, I mean, we'll see what happened in the trial, but almost certainly they were closely held. And then the last thing you might have is just a factual defense of, I wasn't personally involved in the retention of them or their dissemination. And here, that was always, to me, it's like the biggest challenge is, could they prove that? And I think the indictment shows they have pretty strong evidence that he was involved in packing the boxes out of the White House, unpacking them and moving them all around and looking through them in response to the NARA request and the grand jury subpoena and everything. So I always thought that would be potentially his best defense, that, hey, I just wasn't involved. I'm a very important person. But here it shows, I think, that he was pretty clearly involved. So I think all those defenses you might put on a trial are sort of withering away. And all he has left are these basically appealing to Judge Cannon, and trying to exclude evidence out on a bunch of technicalities that we can talk about. But that's what he's going to do, is focus on a bunch of technicalities to try to get it excluded.
So I want to talk to you about the tape last night, because there was some interesting speculation about how CNN got access to the audio. And to my understanding, this was under protective order, correct? And if so, what does that all mean? And how does that change kind of this whole kind of access that CNN got?
Yeah, well, it means that for the copies that are basically retained by the government and then produced to the defense, which this would have been one of those, that both those sides are under obligation to not disclose that information publicly, or else, they would be violating the court's order. The court could get mad and do all sorts of things. But those only apply to the Department of Justice and the defense. They don't apply to anyone else who had a copy of that record. So if Mark Meadows or his staff or whoever else was involved in making those recordings, or Trump's staff had a copy of that and they're not a member of the legal team, like, they're free to still disclose it. They're not bound by that protective order. So I find it extremely unlikely that the Department of Justice would have done this. Almost 100% unlikely. I think that they would have done something like this so early at any point in the case, really. So I would look for someone who wasn't subject to that protective order as being the culprit.
I mean, if you had to speculate, I mean, do you have any ideas on who would have leaked this audio? I mean, who would benefit the most from leaking this? I mean, you mentioned it couldn't have come from the defense or DOJ, so it must have probably come from an external source. But I mean, who would even
Yeah,
do?
I mean, someone potentially in Trump's orbit who was involved in these recordings. There were a few people present who had a copy, who's decided to turn on Trump. That's one possibility. I don't think, there's some notions of, well, maybe the Trump team did it just to get out in front of it. Like, I don't think you would do that here because this would not have come out until trial itself normally.
Yeah.
So I don't know why they would want to get ahead of it, given that there may not even be a trial before the election.
Yeah. Well, it's pretty damning. And I want to talk about the timeline of this case. You mentioned the trial. Walk us through when the trial date is set to be and what we should make of the trial date set by the Department of Justice. I think it was recently.
Yeah, so every defendant has a right under the Constitution and law to a speedy trial. And so what Judge Cannon initially did was follow this law, the Speedy Trial Act, and set a trial for basically about 70 days out from the indictment, which would have been August. But then either side can come in and move for good cause to extend that. And so the Department of Justice smartly got in first, right? Like there's just a lesson for negotiations than anything. Like if you can actually get out the door with your proposal first, it's much more likely that your proposal will be the one, the resolution will be closer to yours than the other side. So I think they were smart to come out and say, let's propose that we're going to hold this in December. Now Trump's team is going to be given an opportunity to come in with their counter proposal to that, which I think is due July 7th or so. And then Judge Cannon will decide. I don't think December is that realistic. I think the Department of Justice probably made that in good faith. Like if everything went perfectly, you could maybe have a December trial, but these cases are so complicated with the classified information that I think, the ideal sort of most realistic schedule would be maybe sometime in June. And I think that's probably what DOJ is sort of ultimately shooting for, hoping for, is primaries are over. It's before the convention. Like that's the perfect window to get it in. But if they came out and proposed June from the start, Trump would just say December of 2024 after the election, and then be negotiating between there. So by starting with December, they've sort of, I think, made it so hopefully they'll end up in June.
Right. I mean, how long do these type of cases usually take? You mentioned that, it could be June 2024 that there's a trial, but how long do they usually take? And kind of, is this the standard timeline that you would expect?
Yeah, I mean, I worked on one. The fastest case I was involved with was 3 counts under the Espionage Act and another criminal statute involving classified information. And that one was set for trial 11 months after the indictment. And that felt like a whirlwind getting ready for that. And that was in the Eastern District of Virginia, which is like the fastest court in the country. It's called the Rocket Docket. And that felt very fast. But that said, like it was thinly staffed, it was staffed like a normal case. I think what the government has probably done behind the scenes is add a ton of attorneys to the case to work on things like the classified discovery, which is usually the thing that slows these cases down. So I think there's a team working behind the scenes to make sure that they can really meet that June timeframe for our trial. But the classified information just makes these cases so complicated, and there's this step-by-step process for litigating it that can just drag on. So that's why while I'm hopeful of June, like I'm still a little skeptical.
Yeah. I'm wondering, because we're dealing with classified information here, does that change at all kind of what the jury can access, kind of potential, I guess, do they have to go through security clearances? How does that change the kind of dynamics of the jury, if at all?
Yeah, for the jury, they'll go through the no moral selection process, the voir dire process. That may be a little more extensive, but it's not like there's going to be no background checks behind the scenes. They're not cleared. The intelligence community and the Department of Justice just trust them inherently by going through the voir dire process that they're going to safeguard this information. I get still why people are concerned. And what would probably happen is at the end of the trial, if they are shown information that's only available to them and not the public, and we can talk about how that would work, probably after the trial, they would be admonished by the judge, that information is sensitive, please don't further disclose it. But with a lot of this stuff, it's ultimately based on trust. And that's something Donald Trump violated, obviously, repeatedly here. And that's why we're in this situation.
Well, can you talk about that a little bit more? The fact, that scenario in which they would be able to, be given access, but the public wouldn't be given access?
Yeah. So the government really has 2 options in a case like this. One is just the records they've charged them with, they could declassify them and then use them at trial, and they would become a public exhibit that you could pull up on the internet and see it.
Mhm.
That's one option. It's pretty extreme. I don't think they'll do that. The other is to use what's called the silent witness rule. And the jury would be shown the records, um, probably completely unredacted or mostly unredacted. And then witnesses would testify about them, but they would not be shown to the public and they would not be posted online or anything like that. Like the public would never see them, the jurors would. And the witness testimony would be in sort of generalities, sort of walking them through the document. Look in paragraph 1, that describes, and they would describe it at a high level. That's sensitive because, and they would describe that at a high level. And then they go on to paragraph 2 and 3. So Trump will argue that that's unfair, that deprives him of due process rights and the right to cross-examine witnesses and the right to an open trial, like, legitimate rights everyone should sort of care about. It's been upheld by several courts, but there's not a lot of like super well-established case law about it. So whether that technique can be used in this case is going to really impact a lot in this case. I think DOJ will try to use it, and the question will be whether Judge Cannon upholds it or not.
I see. So I want to ask you about Judge Cannon, because there's been a lot of talk about her. Yesterday, she denied the special counsel's request to file under seal a list of 84 witnesses that Trump and Nada are not allowed to talk to about this case. What should we make of that? And what else do we know about Judge Cannon based on the very limited things that she's done in this case so far?
Yeah, so that order, I would caution people to maybe wait and see on that order. It definitely was unusual. Normally, something like a witness list could be under seal without a lot of explanation. Every motion that's filed, though, the media is going to challenge it being under seal, and because they want it to be public. And so it's possible, giving her the benefit of the doubt, what she was doing is saying, government, you need to provide a justification to me every time you want to file something under seal. And also think about redacting it. Instead of making it completely under seal, produce a redacted version with lots of information that's not as sensitive unredacted. That's actually, if that's her goal, that's actually a good thing. You should be happy with that. Everyone should be happy with that, because it's going to mean more transparency in this case.
Yeah.
But if DOJ does that, and she's basically said they can have a second attempt at doing that, and then she still says the witness list has to come out, then everyone should be concerned. The other thing, I think it's too soon in this portion of the case to tell, but I went and looked back at her old orders and tried to see, okay, what concerns me most, other than that she got a lot of the law completely wrong and engaged in unprecedented opinions. But from a national security perspective, what did she get wrong? And, initially, remember, she tried to say, well, she tried to halt the prosecution, but said that the national security investigation and reviews could go on. So that sort of was a good sign, right? That she was a little sensitive. But then DOJ came back and said, look, we can't, if the prosecution can't go on and the investigation can't go on, it's hard to separate that from the national security investigation because they're working so closely together. That was something I encouraged DOJ to do. They filed a declaration explaining all that, and she basically dismissed that. And that's when she dismissed that and basically refused to give any deference to this FBI declaration that explained all these harms to national security. That's what's very, very concerning to me. Looking at this from a former CIA lawyer, is she going to act like that to all these other declarations that are coming up?
I mean, are you optimistic she won't be as kind of egregious as last time?
I don't know. Sometimes judges get religion on this stuff, certainly a lot of federal judges have no experience with classified information, and I've seen them, behind the scenes sort of display a lot of ignorance. And sometimes that just sort of continues in perpetuity, and other times they get religion on it, like I said. And so the Department of Justice will have an opportunity, they've already started doing a little bit, to slowly educate her on the legal tools that can be used to protect this information, and then mostly like why it's so sensitive, and also tell her a little more about the case at the same time. But they will be filing declarations with her that explain why this is so sensitive, and if those are convincing, then maybe she'll come around. But probably not. I wouldn't bet on it.
Well, the last thing I want to ask you is the kind of the public element of this, because, and Andrew Weissman said this last night brilliantly on MSNBC, where convincing a jury is one thing, but convincing the public is a different thing, especially now when you have so much misinformation and lies. What do you hope, as both the lawyer, but also former national security official, hope that every American will take away from this document's case, and what it will take to get people to understand and accept the facts?
Yeah, I mean, in this media and information environment, I mean, that's going to be extremely, extremely difficult. I do think just getting the facts out there on trial, like they already did it with the indictment. They did a great job of really not holding back. They probably still held some stuff back, so we'll see what additional facts come out at trial. But I think, I think the to me the message is just accountability, right? Like
Yeah.
what's done is done. With the damage is what he did with these documents and the harm to national security. Like that's done. What our criminal justice system is about in general, but I think especially when it comes to this is accountability, showing that no one's above the law, that he did something wrong, and was frankly giving more and more opportunities than any other citizen would have been given to right the ship. He could have basically come forward with these documents at multiple points earlier and would not have gotten in trouble criminally. So I think the message I hope gets across is accountability. Whether that happens in this atmosphere, like I don't have any good ideas on how to do that.
Well, I agree with you, but you are doing such a great job of just putting out there the facts, and I learned from your Twitter account and everything you do. So thank you for joining me today, Brian.
Great. Thank you for having me.
Of
Appreciate it.
course. Thanks so much. Well, that was a great and very informative episode with Brian Greer, who runs the Secrets and Lies Society, I believe, or Law Society on Twitter. You want to check that out. The handle is @secretsandlaws. Very simple and all spelled out. So AND and laws. He has a great Twitter account, keeps us all informed about the news of the day, the legal news of the day. So thank you, Brian, for joining us today. We've got a great week of On the Move left for you this week, including tomorrow. We're having Brian Van Grack to talk about more of this documents case, kind of what's at stake from a national security perspective. On Thursday, we are going to have the amazing Barry McCaffrey to talk about the whole Ukraine situation, the whole Russia situation, what happened with Prigozhin, what we should make of it. I know there's a lot of confusion about that, so he will join me on Thursday to clarify. And then on Friday, Sari Beth Rosenberg will join me to talk about all of the attacks on teachers. So we've got some great episodes. It'll be live at 6 p.m. Eastern, 3 p.m. Pacific, right here on youtube.com/Politicon or on my Twitter page. So be sure to like and subscribe so you don't miss an episode. And I will see you all tomorrow. Have a great rest of your Tuesday.